Hi everyone, I'm Franche Monica Balde. I'm a criminologist and a law practitioner. Welcome to another first video. I hope that I started this YouTube channel 2 years ago and I wasn't able to consistently upload videos for my intended audience, which are criminology students and maybe criminology practitioners. But I've decided to start again, and I hope I can consistently upload educational videos for your educational use. And I hope you will be with me whenever I upload my videos, and I hope that these will be very essential to your criminology studies, studying your subjects, especially law subjects. And I hope whenever you needed it, just watch this video. Thank you, and let's start. Okay, let's start this lesson with the concept of general law and specific law. So, for those enrolled in Criminal Law 1, maybe you've heard about this already, about the revised penal code and that of the special law. So, what's the difference? What's the general difference of these two laws? So, revised penal code is considered to be our public law, our municipal law, our general law. Special law, on the other hand, it is a specific law in the sense that this law is specific only to a particular act that is in violation of that particular law. While in the revised penal code, this is not only specific to a single act punishable, but it is a combination, it's a code of several crimes. That's why if you look at your revised penal code, it is divided into two, Book 1 and Book 2. Book 1 talks about the nature, the stages of execution. So talks about how will you apply the concept of the laws or the acts or the crimes under the revised penal code. Book 2, on the other hand, Book 2 is now composed of several crimes that are categorized based on the nature of the act. It could be crimes against national security and the law of nation, or it could be crimes against fundamental law of the state, or it could also be considered crimes against persons, which very common, like murder, homicide, rape, parricide, infanticide, or physical injury. There's also a category of crimes against property, like robbery, theft. So revised penal code is basically not only focused on one aspect of a crime, or not one crime, but it is composed of several crimes. In fact, in Book 2, there are 15 titles. Book 2 is comprised of 15 titles. Although the 15th title doesn't carry penalty, so it's a general provision. So basically, there are only 14 penal titles of your Book 2. Penal titles because these are the titles that carries with it the penalty whenever you violate the act or the crime that is, or the law in that particular title. So to summarize, a revised penal code, this is a code of crimes, while special law, this is not a code of crimes because the special law is specific only to a particular violation, such as RA 9165. That's a special law created by the Congress. RA 9165, it talks about the violation of, or it's known as drugs law, okay, as amended, RA 9165. Another is RA 9208, Trafficking in Persons Act. We also have VAUSI, RA 9262, Violations Against Women and Their Children Act. So this particular specific special law is particular only or specific only to that particular aspect of a crime, no? So specific. So how about the implementation, or how about the principles of law? Can we apply it both to revised penal code and that of the special law? So generally we cannot. So I hope you can relate to this if you've already studying with your criminal law 1. So for example, stages of execution. So in stages of execution, we have consummated, we have frustrated, we have attempted. So whenever you started the commission of the act but did not perform all the acts of execution, so maybe that's only attempted. But the attempted generally is only applicable to revised penal code and not applicable to special law. Meaning, walang attempted stage in special law as a general rule. Assuming RA 9165. So walang attempted possession of dangerous drugs. Walang attempted using of dangerous drugs. We don't have that. So the stages of execution, like attempted, frustrated, is not applicable generally to special law. So what's applicable to special law? There's only one stage of execution in special law, and that is consummated. So the act that you did, which is in violation of that particular special law, you'll only violate that whenever you consummate, whenever you perform the act already, all the elements of the act, you have performed it. That's the time that you will be violating the law. So walang attempted, walang frustrated. And like in revised penal code, meron tayong attempted, frustrated, and of course, consummated. Okay? So how about participations of the crime? In revised penal code, we have principal, we have accomplice, we also have accessory. While in special law, we don't have that. The one who can violate crimes in special law are only principals, meaning walang accomplice, walang accessory in special law. Praeter intentionem, I hope you're familiar with that term already. So, praeter intentionem, the person did not intend to commit so grave a wrong as that committed. Praeter intentionem is only applicable to revised penal code and not applicable to the special law. Intent, mala inse, meaning the deliberate intentional commission of the crime, is only applicable in revised penal code, and we don't need to prove that in special law. Meaning intent is not really an element of special law. Since it's not an element, you don't need to prove intent. So we don't need to prove intent anymore in special law. It's not an element as a general rule. However, there are special laws where intent should be proven because it's part of its elements. There are also special cases where participants like accomplice, accessory are also applicable in special law whenever the special law specifically indicated in their provision that it is applicable, or there's accomplice, there's an accessory. In the same manner as stages, if the special law specifically provides in its provision that there is an attempted, there is frustrated, then we can apply it. In some instance also, whenever the special law adopts the nomenclature of the revised penal code, by way of implication, it can be construed that the rules or principles that we can apply in revised penal code can also be applied in special law. So basically, that's the general difference between your revised penal code and that of special law. So they are not the same as to the application of certain principles in criminal law. So that's it for our first comeback video. So I do understand if some of the things I've mentioned you're able to, maybe you're not familiar and able to catch up because maybe you just started your criminal law 1. But if you are in your review program already, I'm pretty sure that you can be able to relate. So for the benefit of those who just started their criminal law 1, I will have in the succeeding videos, we will explicitly discuss each principles of those things I have mentioned. And also just like to add a little, so in criminal law 1 also, you have studied about circumstances affecting criminal liability. Sorry, justifying circumstance, exempting circumstance, mitigating, aggravating. In the same manner, generally, these circumstances affecting criminal liability will not be applicable to special law as a general rule, and it will only be applicable to the revised penal code. So that's it for our first video. I hope you have learned something about this, and I will upload next or succeeding specific videos for those principles I have explained or principles I have mentioned. Thank you and continue to study. Bye.